If you've been charged with DUI, you may be going through a range of emotions. Why did this happen? How could I let myself do it? Am I not an alcoholic? Do I need treatment? Well, a lot of those are personal questions. But they arise because there's a stigma in our culture about drinking and driving. The law is misunderstood in our culture. Many advertisements say don't drink, don't drive. Or if you drink, don't drive. But that's not the law. The law is do not operate a vehicle while under the influence of alcohol. What is under the influence? We've all been to the party and have seen the person who indulges too much and is staggering all over themselves, can't hold a speech. We all grab their keys. We try to prevent them from driving. And yes, we can defend those cases as well. But the vast majority of DUIs are people who believe they are perfectly capable of driving that vehicle, and they get stopped for something minor, maybe not having their turn signal on for the proper amount of time. Maybe they forget to put their turn signal on. Maybe they're going 3 miles over the speed limit. Something minor that we all do whether or not we have been drinking. And they find themselves all of a sudden charged with the DUI. It is important to understand that you are innocent until you are proven guilty beyond a reasonable doubt. That means just because the officers have probable cause, which is a lot lower standard, to charge you with the DUI, does not mean that a jury should convict you of a DUI. It's not about whether or not you should have been driving on that particular day at that particular time. That's a question only you can answer. It's about whether or not the state can prove you guilty beyond a reasonable doubt. There are many things that we can challenge. For instance, we can challenge a stop. Often officers stop people for what we call illegal or pretextual reasons. They normally would not stop someone for going a couple miles over the speed limit. Yet at night, after 10:30 or so, they will, especially if they see you pull out from a bar. That's a pretextual stop. There's many things that we can challenge as it relates to the stop. We can also challenge the field sobriety tests. Those tests were from a sample group of 18 to 20, mid-20-year-old males doing agility tests, walking in a straight line, balancing on one foot, things that we do not do on a normal basis. Yet, 60-year-olds with hip replacements are held accountable to these tests, and officers use that to gauge whether or not they were under the influence. We can challenge these tests. We can challenge the breath test. There are many things wrong with the machines that take our breath sample and get a result. How do those machines work? How do they get their numbers? What assumptions go into those numbers? These are all things that we challenge. I would posit that everything is calculated against the defendant and posited for the state. These machines are not accurate and reliable, and we try to show that to a jury. We can also challenge a warrant if they were to get your blood based upon a warrant. Trials can be challenging and can be stressful, yet you cannot be afraid to take a DUI to trial. That doesn't mean that you're not taking accountability. That doesn't mean that you won't learn from your experience and maybe change some behaviors. But just because you were stopped and charged with a DUI does not mean you are guilty. And here at Johnson Litigation, we will fight to protect your rights and try to prove you not guilty for DUI.